The room was already tense before the main event began. Justice Clarence Thomas, decades of Supreme Court authority behind him, appeared via video feed for a hearing that had been billed as one of the most significant in recent memory. The moment the camera focused on his face, the air seemed to tighten. His expression was unreadable, his tone clipped as he confirmed his presence. The audience wasn't made up of casual spectators. Seasoned legislators, legal staff, journalists, and citizens who'd managed to get seats filled every available spot. At the far end of the panel sat Representative Jasmine Crockett, wearing a tailored charcoal blazer that conveyed both professionalism and readiness. She didn't fidget, didn't glance nervously at her notes. Her eyes stayed fixed on him. Beside her, a senior aide adjusted a stack of documents, papers that had been combed over for weeks. When the chair recognized her, she didn't waste time. "Justice Thomas," she began evenly, "let's talk about the reports concerning undisclosed travel and gifts you received from individuals with potential business before the court." Thomas leaned forward slightly, clasping his hands. "Congresswoman, I have served this country for over 3 decades with honor. I trust you're aware of the independence the judiciary maintains." It wasn't an answer. It was a move to frame the exchange as one between a powerful judicial veteran and a relatively new legislator. "I'm also aware," Crockett replied without blinking, "that public trust in the judiciary rests on transparency. So I'll ask again, have you received any travel, accommodations, or gifts from individuals who had business before the court in the last 5 years? The mood in the room shifted. Thomas let the silence stretch before answering. "Congresswoman, you're asking a question in a way that suggests misconduct. I'd ask you to rephrase." It was a classic deflection, slow the momentum, challenge the form of the question. Crockett didn't take the bait. "Justice, the question is clear. The American people expect clear answers. I'll give you another opportunity." A faint narrowing of his eyes betrayed that this wouldn't be a routine 5 minutes. Thomas spoke carefully about judicial independence and long-standing friendships, weaving in personal history to blur the focus. Crockett listened without interruption. "Then, Your Honor, I want to direct your attention to page 37 of the committee's briefing packet. This is a record of a private flight to Jackson Hole in 2022, paid for by a donor, whose company filed an amicus brief before the court months later. You didn't disclose this. Can you explain why?" Thomas's eyes flicked to his notes. "I'll need to review the specifics before commenting." "I'm happy to provide them now," Crockett said, sliding a copy to the clerk. "But the record will note you can't explain this today." A murmur rippled through the gallery. Thomas sighed audibly. "Congresswoman, I would caution you against implying—" "I'm not implying anything," she cut in, still calm. "I'm stating documented facts and asking for clarity." The exchange felt like a compressed courtroom battle. Every line carried weight. Thomas's next move was to question her motives. "Congresswoman, your line of questioning seems less about facts and more about framing me in a particular light." "With respect, Justice," Crockett said evenly, "my questions are grounded in documented records, many submitted by your own counsel. If the facts are uncomfortable, that doesn't make them less factual. I've given decades to defending the Constitution," Thomas replied. "I would think I've earned the benefit of the doubt." "The American people give trust to the court," Crockett countered. "But that trust isn't permanent. It's renewed through transparency. That's why we're here today." He invoked separation of powers. She invoked the code of conduct for U.S. judges. "This isn't about dictating," she said. "It's about accountability." Thomas maintained he'd adhered to the code to the best of his ability. "That's not the standard," she replied. "The standard is whether a reasonable person, knowing the facts, would question your impartiality. In several instances, they might." "You haven't sat on this bench," Thomas said pointedly. "True," Crockett answered. "But I've read enough of your rulings to know your words carry weight far beyond this room. That's why it matters how you conduct yourself when no one is watching." He called the omissions clerical errors. She called them a pattern. "Reasonable minds might question whether they're accidental," she said. He suggested there were more pressing matters. "This committee determines what's pressing," she replied. "And today that includes your pattern of omissions." Then she slid forward Exhibit D, a signed acknowledgement form from September 15, 2021. It documented a private charter flight to Bozeman, Montana, funded by someone with pending litigation before the court. The form bore Thomas's signature. yet it was missing from his annual financial report. "This isn't a form your staff filled out," Crockett said. "You signed it. You filed it." "If I failed to follow through on the report, it was unintentional," Thomas said. "In United States versus Loughran," she reminded him, "you wrote that where the law prescribes a procedure. Adherence is not optional, it is essential." "Why is it optional here?" "That was about statutory requirements in criminal law," he replied. "The principle doesn't vanish because the context changes," she said. "Public confidence depends on following the rules, the same way you expect others to." Thomas insisted nothing had compromised his impartiality. "The appearance of impartiality is as critical as impartiality itself," Crockett answered. He argued friendships didn't equal influence. She reminded him the public couldn't audit his friendships. They saw benefits accepted and cases decided, and drew conclusions. She moved on. "Let the record reflect this omission. Matches at least 4 others in the last 7 years." Then she pulled a yellow tabbed section from her binder. "Justice Thomas, are you familiar with State of Missouri versus Franklin Industries? 1998, industrial zoning dispute," he recalled. "In your concurrence, you wrote that judicial integrity demands avoiding even the perception of impropriety, particularly where personal relationships intersect with duties. Does that sound accurate?" "Yes," Thomas said cautiously. "Then consider this. The donor who funded the Montana trip also organized a private 2019 retreat attended by parties with active litigation before the court. You participated and later ruled in their favor, 6-3. Thomas called it routine judicial engagement. Crockett countered, "This wasn't an academic symposium. It was an invitation-only retreat run by an advocacy group with cases before you." "You're making an implication I find inappropriate," Thomas said. "I'm connecting verifiable events to your own stated standards. Wouldn't this qualify as a reasonable perception of impropriety?" "Perception is subjective," he said. "That's why disclosure rules exist," she replied. "He claimed to act in accordance with conscience. Then perhaps your understanding should align with the public's right to know," Crockett said, "because millions are watching and wondering if the scales are balanced." He warned that incomplete narratives could damage reputations. "Reputations are protected by transparency," she replied. "When facts are complete, the narrative speaks for itself." She moved to 2011 Senate testimony, where Thomas had called disclosure requirements the public safeguard against corruption. "Help me reconcile that," she said, "with repeated failures to disclose gifts and travel from individuals with vested interests before the court." Thomas said safeguards work in good faith. "Good faith without transparency," she replied quietly, "is a request for blind trust. That's not how the law works." From her blazer pocket she pulled a single sheet. "Are you familiar with Harrington v. United States, 1983? "That was before my time," Thomas said. "It's rarely cited except in one concurrence. You wrote in 1996, Reed v. Missouri Board of Ethics. You relied on Harrington in writing that a judge must recuse not only for actual bias, but for the appearance of bias in the eyes of a well-informed observer. Is that accurate?" "That appears to be accurate. Exhibit F shows you had a 2020 closed door